This is Attorney Zoe Zhang-Louie, immigration law firm specializing in helping entrepreneurs live and work in the U.S. without constraints to their immigration status. And today I wanted to present a little bit of a continuation of what I did in a previous session about using student visas to stay in the U.S. If you recall, there was a policy memo that says that F&M students may be the beneficiaries of a permanent labor certification, so being sponsored by an EB-3 process or an EB-2 process or the immigrant visa petition, and they still would be able to maintain their intention to depart. So F students are what's considered a non-immigrant visa status. But to clarify, this says that this was provided because the visa bulletin wait time has drastically been extended since early 2023 in order to file for their adjustment of status. F students have to wait for their date to be current. So this is saying that you can extend your program if you have not been able to file for adjustment of status. Now, for more information about that, just go back to the previous video. But what I wanted to explain with this one is that we've been getting a lot of questions about, so what if I have what if I'm waiting for an interview at the consulate? Or what if I have an adjustment of status filed? Can I now get student visa, or can my can my children get student visa to come to the US if they already have a DS-260 filed? And the answer is not, we don't have clear answer from USCIS. And no, it's hard to hear because the wait can still be really, really long, depending on how backed up each consulate is when you're waiting for your interview. So even though you have a DS-260 filed and you're in line, you could still be stuck for a long time. But the filing of a DS-260 does confer, as far as we know, it does confer to the immigration officer, hey, I do intend to come to the US. Now you can say, we are going to go back and process, like, look, we are waiting for our interview at the consulate, but my children would like to study in the US in the meantime. We're not going to file for adjustment of status inside the US. We don't know, is the officer going to believe you? What documents can you show to prove that you're going to return home and that that you do not have immigrant intent when you enter into the US with student visa? That's what you need to show, is that you do not have immigrant intent when you enter with a student visa. But would the officer believe you is a different story, right? So bring all that document, and so bottom line is possibly is going to be denied. We don't have set cases to show that. I would recommend that we wait. So end of the day, I would not recommend applying for student visas. And when the officer has to determine they have to guess what your intentions are, whether it's to immigrate using to obtain permanent residence, or to use the student visa to, just go study and come back to the consulate to process that, whether you do not have the intention to immigrate to the US. That's always the gray area. And when you leave that to the officer to decide, they always are more conservative and probably will keep you out, especially after you file the DS-260. So that's why I would not recommend applying for the student visa after a certain point. If you follow me for more advice like this, subscribe to my channel. Okay, that's it.